Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 145, which is the 2018 review podcast. I hope all's well and that Father Christmas was good to everyone. Should anyone out there want a detailed, and I mean detailed, review of the latest Bob Dylan box set, More Blood, More Tracks, I'm more than happy to provide such a review. It's absolutely cracking box set. And I got caught up in a debate online the other night between someone who's trying to tell me that Joni Mitchell's Blue was better than Blood on the Tracks. Absolutely no way. Heresy. Anyway, regular listeners will know we tend to do an episode dedicated to picking out the key points and the key cases from the previous 12 months. And I think it's quite a good idea to take a pause for a moment and think about what have in fact turned out to be the key issues coming through, because it also gives us an indication of where some of the key issues are likely to arise for employers and employees during 2019. So what were the top 10 cases for 2018? Well, I've given up trying to source the relevant Top of the Pops countdown music, and if I'm honest, I think any specific ranking in this order is pretty much a case of comparing apples and oranges. So it's a personal selection of 2018, because I think some cases do stand out. As always, you can access the podcast via iTunes, it's on the Mayor Brown website, or YouTube, and the Twitter feed, Nicholas Robertson, Nicholas Robber, R-O-B-E-R, that is 11, and that's where we have links to the cases. So, first things first, Capita Customer Management Limited and Ali and others, and Hextall and Chief Constable of Leicestershire Police. And right off the bat, I'm starting with a bit of a cheat, I know. I think we're going to take these two cases as one case, because these two cases effectively bracket a key issue. One way or another, we're going to find out the answer during 2019. Starting with the facts of the Capita case, the claimant was a father who wished to take shared parental leave because his wife was unwell after childbirth. However, his wife's maternity pay was at a higher rate because the employer had chosen to enhance that rate voluntarily. But the shared parental leave, which he was eligible for, was only paid at a basic statutory rate. There was no difference between the shared parental leave rate for men and women, but could a man on shared parental leave compare himself with a woman receiving higher maternity pay? The Capita case went up to the AT as an appeal against the decision of the Employment Tribunal that had allowed Mr. Ali to claim that he was directly discriminated against because his shared parental leave pay hadn't been similarly enhanced. But the AT disagreed. They felt that a direct discrimination claim was not available because the purpose of maternity leave was to look after the health and well-being of a woman during pregnancy and in the aftermath of childbirth. Similarly, in reliance on Section 13(6)(b) of the Equality Act 2010, employers are expressly permitted to provide more favourable treatment in connection with pregnancy or childbirth. Either point was sufficient to defeat Mr. Ali's claim. So, at half-time, the employers were leading 1-0. But the Hextall case, however, proved rather less clear-cut for all concerned. In that case, the claimant was arguing that he'd been indirectly discriminated against on the grounds of sex because the shared parental leave is taken more regularly by men, whereas maternity leave is, of course, predominantly taken by women. The Hextall appeal was allowed by the Employment Tribunal, and in that case it was the claimant that was appealing, and the matter went back to the Employment Tribunal to consider again the issue of indirect discrimination. The EAT decided the Employment Tribunal had gone about comparing men on shared parental leave with women on maternity leave to see whether there was a disparate impact and if so whether it was justified in the wrong way. So, to extend our sporting imagery, the referee is currently looking at the VAR to consider whether the claimants have pulled a goal back, and it's a game of two halves and there's all to play for, and we're not yet near the final whistle. Clearly, if employers are at risk of having to pay out additional enhanced benefits to staff on shared parental leave, this is likely to mean that employers think twice about enhancing maternity leave pay. It's all very well for employers to be told that it will not be discriminatory if the practice of enhancing maternity pay but not shared parental pay can be justified. But that's always going to be a risky process for an employer, and there's always going to be an uncertain outcome. And whatever the rights and the wrongs of the situation, it does seem to be a very difficult situation for employers to have to evaluate whether their policy is at risk. So will they want to run that risk at all? Well, the issue isn't going to go away, however, so I'm sure we'll hear more about this, or there'll be other cases raising the same point in 2019. So, next up, City of York Council and P.J. Grosset. And we dealt with this case back in podcast 135. It does have slightly odd facts, but I don't think that should detract from the key point that this case is making. In brief, the facts were that the claimant was a teacher employed by the respondent. He was disabled, and he asserted that due to an inappropriate and excessive workload, his exercise regime slipped, he became stressed and unwell. While suffering from stress connected with his disability, he showed a class of 15-year-olds an 18 certificate horror film. He was sacked for this and claimed disability discrimination. He claimed under Section 15 of the Equality Act, and this provides that a person discriminates against a disabled person if that person is treated unfavourably, quote, because of something arising in consequence of, unquote, that person's disability, and the treatment is not a proportionate means of achieving a legitimate aim. There's a statutory defence to a Section 15 claim where an employer does not know about a disability, that the individual is disabled, and could not reasonably be expected to know about the disability. That defence did not apply here because the employer was aware that Mr. Grosset was disabled, but the employer was genuinely not aware that there was any possible link between his disability, which they knew about, and him showing an 18 certificate film to his class. And, it hardly leaps out at you, does it? Could they still be found to have treated him unfavourably, contrary to Section 15, because of something arising in consequence of his disability, if they did not know that it was a consequence of his disability? Secondly, if there was a link, i.e. they were treating him adversely on account of his disability, was the dismissal a proportionate means of achieving a legitimate aim? The council had set out to check, before dismissing him, whether or not there was a link between the dismissal and his misconduct, and had decided there wasn't. But the Employment Tribunal, on the basis of medical evidence that was given to it, concluded there was a link. The employer's attempt to argue that it had to be aware of a link between the disability and the employer's adverse action failed. So this approach was supported by the AT, which basically upheld the decision. And I think this is key. It means that an employer, once it knows that an employee is disabled, has to be very careful about treating the employee adversely. If the employee can find a link between whatever is causing the employer to treat the employee adversely and the disability, then the employer has to show that, in effect, it is objectively justified. Here, the tribunal found that dismissal was not objectively justified because of the cause of the problem was that the employer had failed to make reasonable adjustments to the individual's workload. Had those reasonable adjustments been made, the dip in the individual's health would not have happened, and the film wouldn't have been shown, etc., etc. So this is very much a warning shot for employers who are aware of an individual's disability but are taking action against that individual for reasons that would be fair if the individual was not disabled. The link with disability requires a higher standard of fairness to be applied by the employer. So next up, DL Insurance Services Limited and O'Connor. This is another case involving a disabled employee claiming under Section 15 of the Equality Act 2010, i.e. that they've been treated unfavourably because of something arising as a consequence of the individual's disability. And again, just by way of reminder, there is the defence if the employer can show the treatment was a proportionate means of achieving a legitimate aim. Here, as in the Grosset case, the claimant was disabled. No dispute about that, and the employer knew it. The individual had had significant sickness absence, was given a written warning, which due to last for 12 months because of her sickness absence. At the point at which the sickness absence warning was triggered, she was 6 times over the trigger point in the respondent's sickness absence policy. The effect of the warning meant that her sick pay was stopped. The claimant asserted that giving her a written warning amounted to a breach of Section 15 because it was treating her unfavourably because of something arising as a consequence of her disability, her absence, and it was not a proportionate means of achieving a legitimate aim. Well, the facts showed the employer had been pretty patient with the individual, and I think she had something like 60 days off in the 12 months leading up to the imposition of the warning. During the disciplinary hearing, the decision-maker accepted that Ms O'Connor's absences were genuine and that she had no control over them. The Employment Tribunal decided, and this wasn't challenged at the AT, that the claimant had been treated adversely because of something arising from a disability. That point, you might think, was relatively straightforward. But the employer then had to identify the legitimate aim which it was seeking to achieve and say that what it had done was proportionate means. The employer said it was looking to ensure adequate attendance levels of staff. That was the purported objective. They said the purpose of giving a warning was to improve the claimant's attendance levels. But both the Employment Tribunal and the EAT said that that was not a proportionate means of achieving that objective. If the absences were genuine and the stated purpose was to ensure attendance, how did a warning enable an employee to deal with genuine absences? There's more than a hint in the EAT's decision. The employer might have been able to justify the decision if it had argued for a different justification for imposing the warning. So this is, in part, a decision on the importance of correctly identifying the objective for the employer of the detrimental action. So, next up, Flowers and others and the East of England Ambulance Trust. Let's move away from disability and talk about holiday pay. This case looked at whether or not it was necessary to take into account voluntary overtime worked by individuals in the relevant period when the employer is calculating their holiday pay. The claimants worked for the respondent. They were, of course, entitled to holiday pay, and there were two different types of overtime pay which individuals were eligible for, and the issue was whether either or both of them had to be taken into account in calculating holiday pay. The first type of overtime payment was non-guaranteed overtime, and there was a second type of overtime payment called voluntary overtime. Non-guaranteed overtime related to shift overrun payments. If the individual was partway through a task and the shift ended, they were expected to finish that task, but they were paid at an overtime rate until the task was finished. The employer, the trust, accepted that this category of overtime pay would be taken into account when calculating holiday pay under the Working Time Directive. However, there was also voluntary overtime. This was completely voluntary. There was no obligation on the trust to offer it, or for the individuals to undertake the work if it was offered to them. The agreed statement of facts in the case accepted on behalf of the claimants. Individuals were completely free to choose whether or not to work voluntary overtime shifts. So what happens if they chose to accept that work? Did those payments get taken into account in calculating holiday pay? The EAT accepted that the right to paid annual leave is an important part of EU social law. Normal remuneration should be maintained for holiday pay so that there is no deterrent from taking holiday by having to accept a pay cut during the period of holiday or as a result of taking holiday. On that basis, the EAT confirmed that the Employment Tribunal was right to say that these voluntary overtime payments could potentially be included in the calculation of holiday pay. It would be necessary to decide whether or not, on the facts, the overtime payments had been made sufficiently regularly to employees to form part of an individual's normal remuneration. But that was a factual question rather than the issue in principle about whether voluntary overtime was excluded altogether from the calculation of holiday pay. So, overtime payments of whatever nature are within holiday pay calculations if sufficiently regular. Next up, Talon Engineering Limited and Smith. If the yardstick of a case's significance is how often it's going to get relied on in 2019, then I think this case is going to be fairly close to the top of any pile. Although it arose in a unionised environment, the same issue is going to arise in a non-unionised environment too. Claimant was summarily dismissed in September 2016 for misconduct. However, the dismissal decision was taken in her absence. She had refused to attend the disciplinary hearing because her chosen representative, a trade union official, could not attend on the rescheduled date. They wanted the hearing adjourned, once again for a longer period. The claimant, let's go back into the facts. The claimant was originally suspended on the 29th of July, attended an investigation meeting on the 9th of August, and on 26th August was invited to attend a disciplinary hearing on the 5th of September. This got adjourned because of her illness. So on 19th September, she's invited to a disciplinary hearing on 29th September, i.e. 2 months after she was initially suspended. Her union officer, who'd been representing her throughout, said he wasn't able to make that date, and his earliest available date was 2 weeks later. The employer refused to agree this. The employer pointed out she had a statutory right to adjourn the disciplinary hearing for up to 5 days from the date set on 29th September, but this request was for a longer delay, and so the employer decided to reject the delay. The Employment Tribunal decided the dismissal was unfair because there had been a failure to postpone. It was far preferable for the employee to attend the disciplinary hearing. All reasonable steps should have been taken by the employer to procure that attendance. The suspension had not, according to the tribunal, been for a particularly lengthy period already, so a further delay would not have been excessive. And the EAT upheld this approach. Now, this is a troubling decision, I think, because most employers faced with an individual who had been suspended for 2 months would feel pretty strongly that the clock was ticking against them. Obviously, as well, if an individual is facing charges of gross misconduct, every day that goes by simply represents an additional day's pay for an individual. So there's a pretty hefty incentive for an individual to delay. I should emphasise the tribunal in this case felt that was not what was going on here. So I think it's highly likely, however, that claimants, either genuinely or unscrupulously, are going to rely on this case to try and push for lengthier adjournments. and during that time they'll remain on full pay, and in the hope of putting pressure on the employer. The employer is going to have to decide when it is right to require the individual's attendance, and whether, if the individual declines to attend, they go ahead and dismiss in absence. If they go too soon, then by itself they will lose an unfair dismissal case. One way through this, and which wasn't taken by the company in the Talon case itself, is to have a full rehearing of matters at the appeal stage of the disciplinary hearing. Obviously, it's generally better if the individual is at the initial disciplinary hearing and represented by his or her chosen representative. In circumstances, however, where the employer feels that the delay is becoming deliberate and the employee is seeking to string matters out as far as possible, it's going to be necessary for the company to reach a point where it says it's not prepared to delay any further. In those circumstances, if the employee does not turn up and is then dismissed, the question will be whether the employer is going to stand by its intention of dismissing the individual. If the individual is dismissed in their absence and there is an appeal hearing, then the individual will be off the books, and so there will be no incentive for the employee to delay any appeal hearing. Equally, if there is a delay, the employer is going to be much more relaxed about it, because it's not as if the individual is being paid in the meantime. If the employer at any appeal conducts a thorough rehearing, then this ought to mean that the dismissal process overall is fair, as the employee will have been able to take part in the appeal stage of the process with their chosen representative. In short, I think employers are going to have to be quite savvy in how they deal with requests for extension which seem, to the employer at least, about delaying the outcome of a disciplinary hearing. So, next case, Agarwal and Cardiff University and others. This relates to a relatively simple jurisdiction issue. However, the consequences are that employees are going to be able to bring more claims in employment tribunals, and so it is a case of practical importance. In the Agarwal case, there was a claim for outstanding salary, which was connected to a period of sickness absence. The individual brought a claim under the Employment Rights Act 1996, Part 2, arguing there had been an unauthorised deduction of wages. Section 13 of the 1996 Act, the old Wages Act provisions, states that employers cannot make a deduction from wages of a worker employed by them unless that deduction is required and authorised by virtue of a statutory provision, or a provision of the worker's contract, or the worker has previously consented to this in writing. If an unauthorised deduction is made, then the employee can claim the deduction back by going to the Employment Tribunal. That's Part 2 of the Employment Rights Act 1996. However, there are also cases around Part 1 of the 1996 Employment Rights Act, and that's connected to the obligation to provide a written statement and particulars of the principal terms of the contract of employment. Under Part 1, the courts have accepted consistently that they are not entitled to interpret the contractual terms they have identified. Equally, under Part 1, the tribunal is not entitled to amend the terms or introduce terms when none have in fact been agreed. In a couple of cases, the AT took the same approach in relation to Wages Act claims under Part 2, i.e. they said employment tribunals were not allowed to interpret contracts of employment. This meant, they said, that if there was a dispute about the alleged underpayment of wages and the dispute turned on the interpretation of the contract, then according to those EAT cases, the employment tribunal was supposed to decline to accept the claim. However, in the Agarwal case, the Court has decided it was wrong for Part 2, and that the approach adopted under Part 1, the no interpretation approach, did not apply to deductions from pay under Part 2. So, in short, if you have a Wages Act claim and the employer's answer is that the interpretation of the contract means that there's been no deduction, the Employment Tribunal is now clearly empowered to interpret and decide on the correct meaning of the terms of employment. In short, it's going to mean that employers are going to find it far easier to bring claims for underpayment of wages, because generally employment tribunals are much quicker and easier to use than the county court. So, getting down to the last few cases, ABC and others and Telegraph Media Group Limited. This is a really important case on the use of NDA clauses and settlement agreements. These are undoubtedly a hot topic at the moment, and the benefit of the Court of Appeal's guidance on the subject is significant. In short, 5 employees of a group of companies made allegations of inappropriate behaviour against a senior executive. 3 of these went through an internal grievance process, 2 did not get that far but raised allegations. All of the claims were settled. Payments were made under statutory settlement agreements. All of them had independent legal advice, and in all cases there were terms under which both sides agreed to keep the subject matter and the complaints themselves confidential, including the amount of money paid. The clauses gave the individuals the right to make legitimate disclosures, including reporting any criminal offences, if they so wished. The press got wind of the story and wanted to publish the allegations and how they had been handled, up to and including the existence of a settlement agreement and the non-disclosure clauses. The employer and the senior executive concerned, the allegedly guilty senior executive, said the information was obtained in breach of the NDAs, and so they went to court for an injunction to prevent publication. 2 of the 5 individuals who had originally made the complaint supported getting the injunction, 1 was opposed to it, and 1 said they'd be happy if their complaint was disclosed, provided their own name was kept out of things. At the Court of Appeal stage, the court had to decide whether it was in the public interest that the duty of confidence set out in the settlement agreement would be breached. The court's view was that it would be necessary to look at the nature of the information, the surrounding circumstances, and to work out on that basis whether it was legitimate for the owner of the information to keep it confidential, or whether it was in the public interest that the information should be made public. Court of Appeal accepted a number of key points. First, if there was an express contractual obligation of confidence applicable to the person who breached the duty, the fact that there is express contractual obligations meant that the duty of confidentiality carried more weight. Provided the agreement is freely entered into without improper pressure and with the benefit of independent legal advice and with due allowance for appropriate disclosures of any wrongdoing to the police, etc., public policy reasons in favour of upholding the obligation, they said, are likely to tell with particular force. Similarly, since the clause had been concluded in a settlement agreement where both parties were represented, quote, it would require a strong case, unquote, for the court to decide to intervene. The court also said, quote, that there was an important and legitimate role played by non-disclosure agreements in the consensual settlement of disputes, both generally, but in particular in the employment field, unquote. On that basis, the Court of Appeal found nothing untoward in including the NDAs in the settlement agreement and granted the injunction enforcing the terms of that clause or those clauses. In short, the Court of Appeal is in essence saying that unless there is evidence of bullying or other similar misconduct that would remove the idea that an employee freely consented to the NDA and the settlement agreement, the employee should generally be held to the bargain that they have accepted. Obviously, non-disclosure clauses must be framed in the right way. We've recently gone through our wording in our precedent documents so that there are explicit exclusions for whistleblowing disclosures, reporting criminal offences, assisting criminal investigations, etc. It's probably also worth going back to look at contracts of employment to see if there are any terms in there which might cut across such necessary disclosure rights. I'm thinking, for example, about the general rules on confidentiality. But equally, I think employers should be under no doubt that if they want to have an NDA in the terms of a settlement agreement, then there is absolutely no prohibition in principle on putting one of those clauses in, provided there are, as I say, the appropriate exclusions. Okay, Timis and Sage and Osipov. I think it's very unlikely that any UK employment lawyer's list of top 10 cases of 2018 would leave this one off the list. It effectively radically changes the way we understand whistleblowing claims to work. It sidesteps some of the protections that were apparently enshrined in the legislation in relation to dismissal claims. Background was that the company dismissed the claimant. An employment tribunal decided the dismissal had been made because the individual had made a protected disclosure. They awarded something of the order of £2 million in damages for the automatically unfair dismissal under Section 103A of the Employment Rights Act 1996. However, the company had no assets by the time the judgment was made. The individual, however, had also taken the precaution of suing the 2 directors, who, he said, had made the decision, which was then implemented by the company. And the case concerns the extent to which individuals who take a decision that is found to result in the dismissal of a whistleblower are personally liable for that dismissal. It's clear that if the individual is claiming there had been an automatically unfair dismissal of a whistleblower, then that claim, that automatic unfair dismissal claim, cannot be brought against individuals. It's simply a claim against the company under Section 103A. It's the same as for any other unfair dismissal claim where a claim lies only against the employer. However, under the Employment Rights Act, it's possible for workers, which includes employees, to bring a claim if they've suffered any detriment as a result of whistleblowing. And this is under Section 47B of the Employment Rights Act. So the question here was whether the 2 directors could be liable under Section 47B for the losses flowing from a dismissal by the company, which would have been automatically unfair under Section 103A. First of all, were they liable for the decision taken by the company because they were the ones that were taking it for the company? Secondly, if the relevant detriment was a dismissal rather than something short of dismissal, was that a type of detriment claim? Could that be brought as a detriment claim where there was an express route for bringing a dismissal claim, albeit only against the company? Court of Appeal accepted the 2 directors could be sued personally. Equally, they could be liable for damages flowing from the dismissal, even though it was the company that had done the dismissal, not the individuals. I understand that the case has now settled. I saw something to that effect on Twitter, so it must be true. So it doesn't look as if the case is going any further. Now, the decision is, to be honest, a difficult one because it means that claimants are able to do better simply by framing their claims as detriment claims rather than dismissal claims. For example, an individual who claims a detriment was imposed on them for blowing the whistle is able to claim damages for injury to feelings. That's not possible in the automatic unfair dismissal case. Secondly, it's easier to show there's been a detriment imposed connected with whistleblowing because the test for causation, the necessary linkage between the employer's detrimental decision and the original whistleblowing, that test is set at a lower level for a detriment claim than for a dismissal claim. But in fairness to the Court of Appeal, I think there are going to be logicalities either way the Court determined this particular case. So I think it's probably a reflection of the underlying legislation rather than the Court of Appeal's view of things here. So, in my view, Section 103A, the dismissal route, is effectively a dead letter now, although the Court of Appeal did suggest that in some circumstances the individual is wanting reinstatement, for example, maybe this claim would still be worth bringing. Employers are going to have to be resigned to the fact there are going to be many more Section 47B claims against individuals involved in the alleged detrimental activity. Employers are going to get used to the fact that presumably managers who are asked to deal with disciplinary or grievance hearings where whistleblowing is already in play are going to need some sort of indemnification because those individuals are likely to get caught up in the litigation too. Various Claimants and Morrisons Supermarket plc. Again, a bit like the Osipov case, I think this is going to be in most people's top 3 cases for 2018, and it's going to be in most people's cases for 2019, I'm pretty sure as well. The facts are relatively well known, but just in case this matter has passed you by, the individual was a senior internal auditor working for Morrisons. He was entitled to have access to personal data about employees. He became disenchanted after being given a disciplinary sanction which he felt was unjustified and legitimately got hold of Morrisons' payroll data, which he then copied unlawfully for his own purposes, put that up on the web, attempted to cover his tracks by using the name of a colleague, and he then tried to encourage newspapers to look at the relevant website which he'd set up. They didn't and reported what had happened. The claimants are a significant section of the Morrisons workforce who are claiming damages for breach of the data protection legislation or vicarious liability against Morrisons. The High Court accepted no breach directly by Morrisons of the data protection legislation other than in immaterial ways which didn't lead to the loss which has been claimed by the individuals. That left only the issue of vicarious liability. Both the High Court and the Court of Appeal accepted that vicarious liability continued to exist as a concept in respect to the auditor's actions, notwithstanding the provisions of the data protection legislation. His wrongful actions, they said, were sufficiently connected with employment to make Morrisons liable under the principles of vicarious liability. And the Court of Appeal said it was up to Morrisons to take out insurance to guard against the risk. The scale of the problem here is difficult to overemphasise. There's something like 100,000 employees whose data was posted out by one disaffected individual seeking to do harm to Morrisons. So the damages claim could be colossal. But there must be some real question marks here about whether it's going to be possible to get insurance, how expensive will it be, how often do this sort of risk actually happen. Morrisons have announced it's intending to appeal to the Supreme Court, which is hardly surprising in view of these issues. So, as I say, I strongly suspect this is going to feature in our top 10 cases for 2019 as well. OK, last pair of cases, Baker and Abellio London Limited and Afzel and East London Pizza Limited. I thought it'd be completely wrong of me not to have any employment cases with Brexit overtones, given that 2019 promises to be, as they say, a very interesting year. Both these cases deal with employers dismissing staff who they believe did not have the right to work in the UK. In the Baker case, the individual was a bus driver working for Abellio. He was a Jamaican national and had a right of abode in the UK under the Immigration Act 1971. The respondent did a workforce audit and asked individuals to produce documents showing their right to work in the UK. It's a slight simplification, but I think it's fair to say the claimant didn't exactly leap into action, and the employers were pretty patient with him, giving him multiple opportunities to produce the documentation they were requesting. The employer then lost patience, dismissed him, because, they said, under Section 15 of the Immigration, Asylum and Nationality Act 2006, they believed he could not be employed without them contravening statutory obligations under the Act. The employer was worried that employing someone subject to immigration control is only possible if the employer has gone through the necessary hoops to get the necessary documentation, proving the right to work. Here the Employment Tribunal accepted the dismissal was fair, either on the grounds that it was mandated by legislation, because the documentation hadn't been forthcoming, or it was on the grounds of some other substantial reason justifying dismissal, i.e. the employers genuinely believed the documentation was required and employment could not continue without that documentation, in their belief. However, the employer lost at the EAT stage. It was clear the individual was not covered by the Immigration, Asylum and Nationality Act 2006, according to the AT, because he was not subject to immigration control. He had a right of abode in the UK. The offence that the employer was worried about was the offence of employing someone who had no right to work. Since he had a right to work, that would have been a complete defence to any penalty claim. The AT also said that a wrongful, erroneous belief by the employer could potentially justify the dismissal in these circumstances. However, they felt the Employment Tribunal had not looked at the reasonableness of the employer's belief in sufficient detail, and they sent it back to them to reconsider. In the Afzel case, the individual was dismissed when he failed to provide the necessary documents demonstrating his right to work in the UK. Again, the employer was concerned about the potential penalties. Having dismissed him, the employee then turned up with the necessary documentation and said he wanted to appeal. The employer, however, refused to set up an appeal to reconsider the decision to dismiss. And the EAT said that the provision of an appeal against a disciplinary decision, is virtually universal now, and so the dismissal was unfair on the grounds the employers should have set matters up for an appeal, which would then have been able to consider the additional documentation, and which presumably would have seen the individual restored to the payroll immediately. So, even though you may have serious concerns about an individual's right to work in the UK, it's still necessary to go through a fair process, including the possibility of an appeal, if you're looking to dismiss an individual fairly. So, thank you very much indeed for listening to this review of 2018. I think there have been a significant number of important cases. I've not mentioned some cases I'm sure would undoubtedly make the top 10 case list for other people. There are no gay cakes in this podcast, for example. Equally, all of this can pale into insignificance depending on what happens in 2019. Uber, which I've also not mentioned in my list of top 10 cases, is likely to go to the Supreme Court, where will the court look to rebalance the categorisation and tests for employee and worker and self-employed consultant. I wonder, my personal hunch is the Supreme Court will be reluctant to interfere in something that's clearly a matter of considerable legislative sensitivity. Let's see. Maybe that's a prediction for 2019, which I'll have to come back and downgrade if Uber proves rather more spectacular. In the meantime, of course, and thank you as always for listening to the podcast. I do wish you all the best in 2019, and remember, Bob Dylan, not Joni Mitchell. Bob Dylan, not Joni Mitchell.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances, so please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.